I will now turn to Clause 78 of the bill, which proposes that psychiatrists will only be allowed to give expert evidence in criminal cases if they are on a court-administered panel of psychiatrists. My main concerns with this panel of psychiatrists is whether the implementation will restrict the defense's ability to effectively conduct their defense. First, I would like to know if there are any price control to regulate and ensure that the cost of hiring a psychiatrist from such a panel will not be excessive and remain affordable to suspects who are financially strapped. Second, will the minister consider permitting ad hoc admission basis alongside this scheme should there be a psychiatrist whose expertise may be very relevant in assisting the court, but who may not be able to meet the admission criteria? I'm glad just now to hear from the minister that they would have such ad hoc admission for overseas psychiatrists. But I'm sure even if we have this list of psychiatrists, no matter how long the list, there'll be a situation whereby we may need to admit some other possibilities. Third, how will the ministry ensure that there are sufficient numbers of psychiatrists on the panel such that it will not limit the pool of experts, witness from which the prosecution or the defense may appoint? When this proposal was first introduced in 2017, some doctors have raised concern on whether the admission criteria may be too stringent and thereby causing psychiatrists to turn away from forensic work, which further reduces the number of psychiatrists who may be appointed to this panel. Finally, while the basis of having a proposed panel of psychiatrists is to ensure that the evidence given by psychiatrists is competently arrived at and objective, there have been concerns that the contrary may result. NUS law professor Jeffrey Pinsler has cautioned that the psychiatrist who is on the panel may be unwilling to state his honest but controversial view for fear that he may appear to lack objectivity and lose his place on the panel. I hope the minister can share with the House what is being done to address these concerns. Now I would like to look at Clause 108, the proposed Section 394F to 394K of the Criminal Procedure Code, pertaining to the introduction of various legal conditions to reopen a concluded criminal matter. There are two main concerns which I have with this proposed clause. The first is regarding the proposed Section 394K, which provides that the applicant cannot make more than one review application in respect of reopening a decision of an appellate court. Mr. Speaker, let's consider a situation where such an applicant has already made one review application already. Years down the road, the applicant comes into possession of new evidence which may potentially prove his innocence. Such an applicant would be precluded from being able to bring another review application based on the strict wording of Section 394K, which only permits him to make only one review application which he has already exhausted. If such an accused person is able to obtain new material which may prove his innocence, I do not think the law should be so rigid as not to permit such an applicant to reopen his case. The second concern I have with is the proposed Section 394J of the bill, which provides that the applicant in a review application must satisfy the court that there is sufficient material on which the appellate court may conclude that there has been a miscarriage of justice in a criminal matter. One of the conditions that the accused must show is that the material cannot be adduced in court earlier, even with reasonable diligence, and that the material is credible, substantial, powerfully probative, and capable of showing almost conclusively that there has been a miscarriage of justice in the criminal matter in respect of which the earlier decisions was made. This section is a relatively high threshold standards for accused person to satisfy in order to reopen their case. I'm worried that such a provision might preclude the accused person who may not be able to meet such high threshold, but nonetheless are able to show evidence that might prove their innocence. Take for instance, accused person whom self-represent themselves without the benefit of legal advice. A self-represented suspect may not know or appreciate that particular evidence or material which he or she possess may be material or relevant to proving their case, and thereby did not adduce it when the case was ongoing. Mr. Speaker, in such situations where the suspect cannot be said to be deliberately omitting the evidence or material when the case was ongoing, such a suspect should not be prejudiced from taking up another application to adduce or obtain such material when the said material can potentially prove his or her innocence. Given that the justice system is subject to human fallibility. We should have a justice system that is flexible enough to correct such human errors when it occurs. I therefore hope the Minister can reconsider this proposed Section 394J and perhaps create an exception under the proposed section to allow meritorious cases. For considerations, perhaps such an exception may provide that accused person who did not intentionally or deliberately not disclose such evidence during the criminal proceeding are not precluded from reopening a concluded case. Mr. Speaker, I do appreciate that finality in the criminal process is an important principle, but such finality must not come at the expense of rigid rules, precluding the court from rectifying potentially miscarriage of justice. Also, while I understand the high threshold standard set out in the proposed 394J is also to keep floodgates of unmeritorious cases shut, but as the word of the Court of Appeal in the case of Yong Wee Kong, I quote, "The floodgates argument should not be allowed to wash away both the guilty and the innocent," unquote. Mr. Speaker, there are many other amendments contained in the bill that are commendable and steps in the right direction. I support this bill, but I hope that the Minister will address the 4 areas of concern that I have shared in this House. But finally, I also want to draw attention to the proposed amendment in the evidence amendment bills. I applaud the move to protect victims of sexual offences and child abuse. In the ST report about a case of a 36-year-old man sentenced to 16 years for molesting and raping his mother, the report outlined how the defense cross-examined the victim, a woman who was a sexual abuse victim. After reading the article, wrote to Aware to voice her concerns about unrestrained cross-examinations. She has given permissions for me to share her thoughts about what she felt as a victim when reading about that cross-examination. I will read a portion of her letter. For me, I quote, "For me, being attacked by someone I love was confusing and shocking. You're trying to make sense of the world to comprehend what the heck just happened, trying to figure out why he didn't understand you, how this massive miscommunication just occurred. Your mind is nowhere near trying to seek revenge or justice. Going to the police means getting that person into trouble, and you still love that person. And why would you tear up your life even more by going to your family? I couldn't bear their concern or worry or anger. Until today, it's really hard for me to use the word rape, or even, perhaps more accurately, forcibly sodomy, to describe what happened. Those words are forceful, heavy, have all sorts of violent and awful connotations. Just because victims don't use certain words doesn't mean that what courts understand that thing to be didn't happen to them. And I remember going, quote, about my usual routine, unquote, as well. Why not? I had a lecture to give the next day. I had students to meet. Life goes on. We still have responsibility to fulfill, jobs to tend to. Other people's lives don't just ground to a halt because of what happened to you the day before. I don't know why lawyers or indeed people in this day and age continue to believe that sexual assault victims must all behave in a certain way after their incidents, or else they must be lying. Maybe they just don't understand. But what really concerns me is that these attitudes are brought into courtrooms. I don't think I can defend how I behaved after my incident many years ago. I certainly couldn't do it while facing a senior counsel. I don't think I could withstand being put on trial for how I behaved after the incident, as if how I behaved has anything to do with how I feel even years after the fact. I cannot imagine being a woman trying to bring her rapist to justice in courtrooms where this kind of arguments are used." Unquote. Her powerful sharings remind us of how victims really need to be protected with great sensitivity and care. I wish the amendment would go further in putting more restrictions in how cross-examination should be done. The court must have a duty to ensure that victims are not re-victimized, being asked questions which are unduly annoying, harassing, intimidating, offensive, oppressive, humiliating, or repetitive, or has no basis other than a stereotype. I also would like to suggest that defense lawyers be encouraged or required to attend some training to sensitize them to what sexual assault victims go through before they take on such cases. insensitive cross-examination not only hurts the victim on the stand, but also deters others from bringing the case forward. I think this bill is an important step and hope we can continue our effort to protect the victims of sexual offenses and child abuse. Thank you.